Right, welcome everybody to a new webinar in our webinar series, ISDS webinar series that Association Arbitry has been running since February. My name is Nevena Yevremovic. I'm a co-founder and the former president of the Association Arbitry, and I have a distinct pleasure of moderating today's sessions with our dear guest, Dr. Crina Baltag. For those of you who are new to the webinar series and have not had an opportunity to work with Association Arbitry or attend our webinars before, just a brief introduction. So the Association Arbitry is an arbitration professionals association based in Bosnia and Herzegovina, and our work primarily focuses on bringing trends, among other things, in commercial arbitration and investment arbitration to legal and business community in Bosnia. So today's topic, the Energy Charter Treaty and environmental, social, and governance issues, is particularly relevant. As we were just discussing before you all joined, Bosnia and Herzegovina is on one side on the path of joining the EU, and on the other side experiencing quite a crisis in its energy sector, especially in the context of transition from fossil fuel-based energy sources to green or renewable energy sources. So today's topic is quite relevant for our region and is also relevant in the context of the Energy Charter Treaty itself, as we've discussed with the closing of the negotiations coming up now in June. So it's timely to kind of revisit what has happened and what we can expect as the outcome of the modernization process. So in case we have anybody here who hasn't had a chance to kind of work with or be familiar with the Energy Charter Treaty, just kind of again a brief introduction. So it's a multilateral treaty that was signed in 1994. Today it has around 50 signatory states, and the purpose of the treaty is to kind of facilitate energy-based investment and energy-related transactions. So the signatory countries to the ECT have a treaty obligation to ensure protection of those investments, and ECT as such does not differentiate between green and kind of fossil fuel-based energy sources. And at the same time, all of these countries that are signatories to the ECT are also signatories to the Paris Agreement and are members of the UNPCC. So they have also an obligation to kind of move forward to net zero or kind of take efforts in combating climate change. And this tension between investment law on one side and transition to clean energy sources as a way of combating climate change is prevalent precisely in the context of ECT. So what we're going to talk about today are what has happened before, what has led to the modernization efforts that began in 2018. Out of the cases that have been reported today, so there are around 145 recorded cases under the ECT. What are some trends that we have been seeing and how these trends can impact the modernization process and other topics? And with me today, as I mentioned before, is Dr. Crina Baltag. And we're quite excited to have her as our guest speaker. So Dr. Crina Baltag is Associate Professor in International Arbitration at Stockholm University and a qualified attorney at law since 2004. She has extensive practice in international commercial and investment arbitration, international dispute resolution, private and public international law, and that extensive practice, of course, covers not only her academic work and teaching work, but also her work as a sole arbitrator and a co-arbitrator in ICC, LCIA, and other institutions' cases. Professor Baltag's academic work includes the leading publications on the Energy Charter Treaty, ICSID Convention, the Future of Investment Treaty Arbitration in the EU, and she has also published numerous publications in leading legal journals and reviews, including a publication on the denial of benefits in investment law as part of Max Planck's Encyclopedia of International Procedural Law, published in 2019. She's a member of the Stockholm Chamber of Commerce Arbitration Institute Board, editor of the Kluber Arbitration blog, co-managing editor of ITA Arbitration Report, and member of editorial boards of prestigious journals and book series in the field, including of the Journal of International Arbitration, European Investment Law and Arbitration Review, and World Trade and Arbitration Materials. So Crina, it's such a pleasure to have you here, and a warm welcome. Thank you for taking your time to join our webinar series.
Thank you very much, Nevena, and thank you to Association Arbitri for the wonderful series of events, and in particular for this timely discussion on the Energy Charter Treaty. And I'm very happy to see everybody in the audience. And thank you very much for a Friday afternoon dedicated to this.
Absolutely, absolutely. And I think the number of our attendees only showcases the interest in the field and in this particular topic. So maybe we can start off by kind of zooming in the modernization process, ECT modernization process in particular, and kind of setting the scene by exploring what is the purpose or the ultimate goal of this process.
I think the answer starts with your introduction, because you're mentioning the time when the Energy Charter Treaty was put forward for signature and entered into force. Some of you familiar with the Energy Charter Treaty process and the Energy Charter Treaty know that this was the treaty was a European idea. At the meeting of the European Council in Dublin in 1990, the then Dutch Prime Minister suggested to establish a European energy network. And it makes sense because we're talking about the 1990, exactly after the fall of the communists in the Central and Eastern Europe, the dissolution of the Soviet Union, and obviously the need to secure energy resources coming from the eastern parts of Europe. So we are talking about the 1990. The idea was initially to have the secure supply from the east, as I said. And what was interesting in the negotiation process was the involvement of non-EU, or at least I would say, Central Asian states. As some of you know, the United States, Canada, Australia, Japan being a contracting party to the Energy Charter Treaty, they got involved in the process, maybe not finalizing it, with different interests obviously coming at the negotiation table. So this explains a little bit where we are. The Energy Charter Treaty process commenced formally with the 1991 signature of the European Energy Charter. And we have now an international energy charter. So in fact, the modernization process of the Energy Charter Treaty has commenced before 2018. Before we get to the goals, I would like to stress that there was, I would say, a strong proposal in 2009. And some of you remember why 2009 we had the crisis, the gas transit crisis with Ukraine and Russia, and probably, I would say definitely, but probably the Energy Charter Treaty and the process and the setting with the contracting parties and the signatories of the European Energy Charter that helped in resolving that crisis. But that was also the point when Russia said we need to modernize the Energy Charter Treaty. And there was a proposal in this way, which was not taken on board. You know very well that Russia decided not to sign the Energy Charter Treaty in the end and has left the Energy Charter process altogether. But that was exactly the moment when the Energy Charter conference in 2010 approved this roadmap for modernization of the Energy Charter Treaty. We'll get to probably more to the process itself. But just to say that where we are today is justified also by the nature of the Energy Charter Treaty. Obviously, we're not in the same setting as in 1990 with the type of energy resources. Obviously, we have the transition from the, as Nevena was saying, the transition from the fossil fuel energy to the renewable energy. We have international commitments aim to address climate change and protect the environment. We have a change in the from soft law obligation to more hard law obligations of states when it comes to responsibility for human rights and I was saying environment, but also for corporations being more engaged and obliged to respect this fundamental rights. So it is, on one hand, a natural evolution of a treaty, which is reflected in the fact that the setting or the initial framework of the on which the treaty is based has evolved itself. We also have something that also Nevena was alluding to, some dispute resolution cases, in particular arbitration, over 140 cases. And as you know, there is a lot to learn from applying a treaty in practice. So there is a bit of discontent in practice coming from the states, but also not only from states, equally from investors and states. There are some provisions missing from the treaty. And it's important when you start to address the treaty to do it in one go. I would just conclude answering your question that the goal of the Energy Charter Treaty modernization process is exactly in the title of the process, which is modernization, aligning it with what we have today, as I was saying. We had at the initial stage of the this 2018-19 modernization process, the contracting parties have stated exactly what would be the goal of this process. There are different objectives, obviously. I was saying everybody comes at the table with a different goal. The European Union has stated specifically that the modernized Energy Charter Treaty should aim at establishing clear rules on a broad number of investment-related issues, and that the modernized Energy Charter Treaty should reflect climate change and clean energy transition goals. On the other hand, there are contracting parties, for example, Japan, that stated that the Energy Charter Treaty should not be modernized.
Exactly. I mean, the idea of kind of not having a clear understanding of where the modernization process should lead is quite fascinating. I mean, there have been 11, we'll get to some of the reasons why we have these diverging thoughts in the context of criticism of ECT and whether that criticism is justified or if the problem maybe lies elsewhere. But in the context of the process itself, since 2018, there have been 11 rounds of negotiation, the April round ending today, new rounds coming up in May, and then the expectation is that this process of modernization will end in June with some outcome. So again, in terms of kind of the setting the framework for discussion further, can you tell us maybe what are some of the main milestones, if any, in the process so far? And then we will talk about later to what extent these outcomes are satisfactory to different states depending on how they themselves see the modernization process and the goal of the modernization process.
So that's correct. The expectation is to have the final meeting of the modernization group in June. One thing is to stress from the outset is that this is a confidential process. Some of you are following closely the UNCITRAL Working Group 3 on the ISDS reform, which is public and loud. Other reforms and other discussions, but this one in particular is confidential. And this was the decision of the contracting parties to the Energy Charter Treaty. You would wonder why. I would guess it is easier to progress in negotiating the treaty without having the public perhaps engaged to a large extent. Although at the outset of the process, there was an engagement with the society and with the specialists in the field, and there are discussions. Obviously, being at the table, it's restricted to the contracting parties. There are leaked documents from time to time, So in December last year, we had one document reflecting the proposed changes by the contracting parties, which is something that I'll use today as well, and it's quite useful. We had, I was saying, the goals set by each contracting party at the beginning of the modernization process, with some suggestions as to what should be addressed in the context of the modernization process. And of course, we had the European Union, the Commission has made public its position on the modernization process, on the provisions, and including the language of the new provisions in the Energy Charter Treaty. So we have some information, but we don't have the full extent of the process. And I see there is a question asked already, and perhaps we'll start with that because Nevena was mentioning that the process has started in 2018. It was at the end of 2017 with the meeting in Ashgabat that the contracting party said, now it's time, the time is ripe to start the negotiation for the modernized treaty. In 2008, the framework was implemented with the establishment of the subgroup, the modernization group. The initial chair was changed. We have now Lukas Stifter, who is representing the government of Austria, is now the chair of the modernization group. And I would say that he's doing a brilliant job, and in particular in keeping everything on track during COVID times. We have the meetings, as Nevena mentioned, at least 3 or 4 per year. And it is interesting because the first meeting came after COVID, or at least the lockdowns started. So it was quite efficient in moving all this discussion online. Now, after the meeting in Ashgabat, when some directions were put forward to the contracting parties for the modernization, there was a list of the subgroup, the modernization group came up with a list of topics to be addressed. So, and I was saying we have a question about Article 26 of the Energy Charter Treaty. That is not on the table. And I know we're going to discuss the effects of ACMEA and post-ACMEA on the Energy Charter Treaty. This is not or at least as far as I know, because obviously I was saying it's not transparent. As far as I know, at least at this point, there was nothing put forward on the Article 26. That is not on the table. We have obviously the definitions that are being discussed, the definition of economic activity in the energy sector, the definition of investment, investor, the standards of protection, Article 10 and the following, the fair and equitable treatment, MFN, indirect expropriation, and we have certain provisions which are to be included in the Energy Charter Treaty, the new one, as is the right to regulate. We have the valuation of damages, we have third-party funding, we have sustainable development and corporate responsibility. And of course, there are provisions that are no longer needed in the Energy Charter Treaty. I was going to point out to this in the previous question. Nevena has mentioned already the benefits of the Energy Charter Treaty. I mentioned some. A few would remember that Energy Charter Treaty came at the point when not all the contracting parties to the Energy Charter Treaty were WTO members. And the provisions in the Energy Charter Treaty helped the transition and obviously to the WTO. So there are certain examples of provisions that are no longer needed in the Energy Charter Treaty, let's clean our house a bit and make it a bit more simple. So as we are, most of the provisions that I mentioned, or at least most of the topics that I mentioned before, have been dealt with and negotiation concluded, which means that we probably will be at the stage after June that the modernization group will have to sit down and actually draft the new provisions based on the negotiations. I can tell, at least from time to time, and at least after each meeting, the modernization group and the Energy Charter Treaty Secretariat releases a short statement on what was negotiated and concluded. And in the previous round, for example, denial of benefits clause that we're going to discuss today as well was one of them.
Yeah, exactly. So the official website of the Energy Charter Treaty kind of contains a timeline of the modernization process. So if some members of our audience didn't have a chance to look at it, they can. And it just describes kind of the context of the discussion and lists the topics that were discussed. I was particularly interested to see sustainable development and responsibility of corporations mentioned in one of the latest summaries. So I'm personally quite interested to see what will be the outcome of those discussions once we get to the drafting stage. Before we move on with the discussion, there was an interesting question in the chat, and I'd like to get to that question on the interpretation of ECT or joint reading of ECT with international agreements on climate change a little bit later. We will have a special webinar series, a special webinar on the Climate Change Council's recent report. So just so that you are aware, we will kind of have a deep dive into the report and discuss the impact of it going forward. But to stay within the context of the modernization process, the information that has been available, for example, the EU information on their proposed changes, has nonetheless received some criticism and scrutiny. So, for example, the Institute for Sustainable Development and the Client Earth NGO filed a brief to the European Commission criticizing and basically arguing that the proposed changes are cosmetic and that they will not, in fact, support, well, not that they will not support, that they will undermine EU's efforts in combating climate change. And EU is quite kind of an important player in this modernization process. And of course, these are not kind of isolated concerns. So what would be the main points of this criticism? I mean, is it really feasible to expect that the modernization process will reflect climate change goals and clean energy kind of goals, and that it will contribute to achieving the objectives of the Paris Agreement? And the reason why I'm asking this is because when you look at the text of the Energy Charter Treaty, it's not that it doesn't have any provision on environment or any kind of ground that would allow tribunals, or that in the interpretation and application of the treaty, that it wouldn't allow for kind of bridging ECT with climate change and environment protection standards. It's just that has been absent from practice so far. So to what extent is this criticism justified? Is the modernization process the appropriate way of dealing with this? And can we really expect that the outcome will be a satisfactory one from the perspective of combating climate change efforts and achieving net zero? What would be your thoughts?
As always, the truth is in the middle. But I would start by first of all, highlighting as you said, that the Energy Charter Treaty actually is one of the first treaties to address environmental concerns, and in particular in the context of energy investments, this is essential. At that time, the provision concerning environment in the Energy Charter Treaty, we're talking about the 1990s, was as good as one could get. There was not much thought put into the protection of environment and climate change in the 1990s. And the focus at that time was to make sure that we have the security of the energy supply in place and guaranteed under the treaty. So the environment provision in the now Energy Charter Treaty doesn't really satisfy the requirements that we have at international level and not even at domestic level. Now, having said this, the second point is, as you mentioned, Ivana, is that it's not that the Energy Charter Treaty doesn't cover different types of energy resources. To the contrary, it's quite comprehensive, and it was quite comprehensive for its time. In terms of arbitrations, I think this is quite tells us a lot, because out of the 136 arbitrations, there was a survey exactly on this point. 136 cases, today we have more than 140, 83 were on renewable energy and only 44 on fossil fuel energy. So this doesn't say that the Energy Charter Treaty is biased on fossil fuel energy or otherwise. The problem that we had is, first of all, there are some provisions missing from the treaty. The second point is that at international level and at domestic level and regional level, now we have certain commitments that states and regional economic international organizations such as the EU have to honor and comply with and effectively implement. Now, there is a fine balancing act, as we know, between what you promise and commit to your investors that you actually attract to your country, and what you have to change, and what legislative changes and you have to put forward in order to fulfill these international obligations. And we're talking about the Paris Agreement, but also obviously we have the EU commitment towards the clean energy, the 2019 EU clean energy package. And these are very strict obligations with a very strict timeline. So how do you do that in practice? Well, in practice, you can do as much as you can to make sure that obviously investors will not come back and ask for millions in order to be compensated for this change in the legislative framework. Now, we had loud cases so far coming from this transition to cleaner energy, and Vattenfall is one of them. But we also have pending cases, the two exit cases against the Netherlands, the RWE and Uniper, and we have others probably coming. So obviously there is a concern, and I was saying balancing all these obligations that are put forward. Now, what is the proposal? And I think, and the European Union text proposal for Article 1, Paragraph 4 of the Energy Charter Treaty, which deals with energy materials and products, is trying to do exactly this. The current definition of investment in Article 1.7, Paragraph 7 of the Energy Charter Treaty includes energy resources from fossil to non-fossil energy resources. And one proposal was we need to eliminate this. Well, we cannot eliminate because obviously we have them. But what the European Union tried to do in this Article 1, Paragraph 4 is to have a gradual phase out for the protection of fossil fuel investments. And this is meant to be correlated with I was mentioning the 2019 EU's clean energy package. So what is happening, and of course with the modification, because the Energy Charter Treaty has annexes, and in particular annexes EM1 and 2, which are very important in the context of the definition of investment and the definition of energy materials and products. So the proposal here is to have a gradual, as I was saying, phase out until 2040 for the protection of fossil fuel energy investments. So we have a gradual limitation in the protection. And that depends largely on the type of energy resources. We are talking about coal, natural gas, petroleum products, electrical energy. It much depends on the how much they're emitting. For example, we have less than 380 grams of carbon dioxide, for example, for a phase out at the second stage. So it much depends on different technicalities, but the idea is we're going to give up first on those that are really polluting, and then gradually Part 3 of the Energy Charter Treaty on the protection, promotion, protection, and treatment of investments will no longer apply to these fossil fuel energy resources. I think this is the best that one can get, given all the elements that I mentioned before. Of course, we don't know what will be negotiated. And I also have to put the flag here. Some of the contracting parties to the Energy Charter Treaty are Central Asian states. Central Asian states are fossil fuel energy countries. I cannot tell you what is the negotiation table, but I can imagine that there will be some opposition when it comes to the EU proposal. The other aspect, before we move to the next point, is I was mentioning there are some provisions missing in the Energy Charter Treaty. We're going to look at the right to regulate. This is an important piece of the puzzle, but the new proposal for the modernized Energy Charter Treaty has a lengthy provision on sustainable development. And it does more than some of you are familiar with the Dutch model BIT, with the new Canadian, the FIPA, the model treaty, all the new generation of treaties that are trying to put together comprehensive provisions on sustainable development. The proposal for the Energy Charter Treaty is pages and pages of articles on sustainable development with specific reference to international treaties. And I think this is something that we've seen in the practice, reluctance from arbitral tribunals to rely on these international instruments, either under the Vienna Convention on the Law of Treaties, Article 31, General Principles of International Law. It is more than one would expect. And we have, specifically on climate change, we have the references to the, obviously mindful of the fact that we had the 2021 United Nations Climate Change Conference recently. We had exactly what a tribunal would need to look carefully to these elements. That probably is the criticism put forward.
I just want to kind of shift gears slightly and stay with the definitions before we move on to kind of discussing the impact of cases and whether the final product will give tribunals what they need in deciding these issues, as you've mentioned. In addition to the changes of that notion of investment, are there any changes to the notion of an investor? So what are, you mentioned denial of benefits in that relation as well. So can we briefly discuss that before we move on to talk FET and right to regulate in light of the cases that have emerged in the past years?
Yes, and this is an important change. And it relates obviously with what we were mentioning before with ACMEA, a bit more hands-on by the states as treaty makers. Who are you allowing the benefits of the treaty? So there are different proposals. The proposal of the EU is to include an obligation that legal entities will show that they have or they are engaged in substantive business activities in the territory of a contracting party. And immediately this takes us to the thought of eliminating this companies registered in fiscal paradises with no activity whatsoever, treaty shopping, and so on and so forth. There are certain proposals from Azerbaijan and Turkey where for legal entities, they would request to be constituted for profit, which means that the broad definition of investor legal entity that we had before or we still have in the Energy Charter Treaty, any kind of company or other organization will no longer be available. For example, I was discussing at some point that if NGOs can to some extent be investors under the Energy Charter Treaty. In theory, yes, with the new proposal, if adopted, saying for profit, obviously that would not be possible. For natural persons, we had the discussions about dual nationality, dominant effective nationality. This is also on the table to limit the access. But I wanted to go back to the substantive business activities. And probably that will be included in the final version of Article 1, paragraph 7, defining the notion of investor, because the new generation of treaties, they do this already. So if you look at the Dutch model BIT, we have there this requirement, including a list of activities that would have, should be considered in satisfying this requirement. This requirement actually comes from Article 17 of the Energy Charter Treaty as it is. And the substantive business activity was actually one of the elements in the consideration of the denial of benefits clause. For those less familiar with the denial of benefits clause, in the most important part of it, it says if an investor is owned or controlled by a third state, so not the contracting party to the Energy Charter Treaty, and that investor doesn't have substantial business activities in a contracting party to the Energy Charter Treaty, then the benefits of the Energy Charter Treaty can be denied. That is, you're not an investor, you cannot claim fair and equitable treatment, and so on and so forth. In the practice of the Energy Charter Treaty, in only one case out of many, I would say over 20, a tribunal upheld the denial of benefits clause, and that was recently in a case against Ukraine before the Stockholm Chamber of Commerce Arbitration Institute. The threshold was almost impossible to be satisfied by the contracting parties to the Energy Charter Treaty. A respondent in Energy Charter Treaty arbitration case had that probatio diabolica, almost impossible. So what the proposal now is taking from Article 17 of the denial of benefits, substantive business activities, moving to the definition of investor. The most obvious consequence is the shift in the burden of proof. It is no longer the contracting party, the respondent, that has to prove that an investor doesn't have substantial business activity. It is the investor that will have to prove that it has substantive business activities. This is important, and probably with what some of us might think that maybe investors will go abroad, register abroad, and then come back and take advantage of Energy Charter Treaty or any intra-EU or any treaty post-ACMEA will probably not be possible because of this. An investor needs to maintain this substantive business activity. And there are other issues with the denial of benefits clause that will be addressed in the modernized Energy Charter Treaty. I'll not get into this now because it's not our focus, but it is an important consequence for states, for contracting parties in particular.
Mm-hmm. So, I mean, these changes kind of, again, aim to maybe reconcile or contribute to this in search for balance between what ECT was meant to do before and how it can play a role in this kind of global policy, global consensus towards achieving or combating climate change through how we consider what an investment is and who an investor is that can have or enjoy the benefits of protection under the ECT. And yet, I mean, the criticisms still are quite prevalent in the sense that on one side, we're dealing with investors that are fossil fuel, in the fossil fuel industry, quite powerful enterprises that might threaten, and often threaten, at least some reports have alleged that, and use threats under ECT claims as a way to combat any regulatory changes, and we have that kind of preempted regulatory chill on that side. And then at the same time, on the other side, we have cases such as Spain, which was amongst the first to kind of bring forward regulatory changes to attract renewable energy sources, and then later on retract those that favorable regulatory framework because it couldn't deal with the high input of investments in that context. And we have several kind of several lines of cases against Spain, Italy, and Czech Republic. So states have different approaches in dealing with this. With these issues. So Italy, for example, withdrew its status under the ECT in 2016. Spain has the highest number of cases. And then in almost all of these cases, we have this tension between the fair and equitable treatment, generally expropriation claims, and discriminatory measures on one side versus the state's right to regulate on the other side. So the question is it really a matter of limiting the state's right to regulate? And in the examples of Spain, is it more a question of how states exercise that right to regulate in relation to legitimate expectations of an investor? And if in the modernization process, we will have any changes to the right to regulate and the fair and equitable treatment provisions as a kind of response to the case law that we have seen so far. I appreciate this is a handful of questions.
Briefly,
I know it's a big topic. Yeah.
I would say that also this obviously this criticism comes from the fact that the plus 40 cases against Spain, we are talking about the same instrument. The issue of inconsistency and lack of predictability, obviously, it's one that is strongly voiced by Spain in particular. And I'm thinking here about the UNCITRAL Working Group 3, where this is inconsistency is one of the concerns identified by UNCITRAL, and based on that, reform options are being suggested, one of them being the multilateral investment court. But here we have one instrument. It's not, we don't have 3,000 bilateral treaties that one would say each treaty is a treaty, has its language. The Spanish cases, at least on the facts, are similar, if not identical. We're talking about the same provision in the Energy Charter Treaty. So the frustration is, I would say, at least justified. Of course, each case comes with its own peculiarities. And obviously, the arbitral tribunal is called to interpret the Energy Charter Treaty in the light of the Vienna Convention on the Law of Treaties. We don't have that body like NAFTA has coming and interpreting bindingly for everybody, for all the contracting parties and tribunals and so on, the provisions of the treaty, which, by the way, was one of the suggestions of the contracting parties for the modernization of the Energy Charter Treaty. I'm not sure if it's going to be reflected after June or not. But there are 2 points here. The one, I was saying, interpreting the provisions, the existing provisions of the treaty, and the second, what is missing from the treaty. So let's start with what's missing from the treaty. We have the Energy Charter Treaty has the exceptions, Article 24, but it doesn't have the right to regulate of the contracting parties. One would say, well, the right to regulate, it is a customary international law. You don't have to provide that in the treaty. It's not necessary. Tribunals can very well deal with this without having a specific provision. Yes and no. And in particular, in the way Article 24 exceptions is formulated, that obviously we did not have any reference to, for example, public security, public order. We only had necessary to protect human, animal, or plant life or health, but we did not have necessary to comply with the laws and regulations which are not inconsistent with the provisions of the Energy Charter Treaty, so on and so forth. So the provision that we had was quite general. Now, the right to regulate provision, which is now suggested to be included, reflects, going back to the cases, reflects the experience of the states. The contracting parties, the contracting parties reaffirmed the right to regulate within their territories to achieve legitimate policy objectives. There is a paragraph added which firmly states that for greater certainty, the provisions of Part 3 of the Energy Charter Treaty, which is fair and equitable treatment, expropriation, and so on and so forth, shall not be interpreted as a commitment from a contracting party that it will not change the legal and regulatory framework. These are the Spanish cases. So the right to regulate, the fact that a state has obligations under the Energy Charter Treaty, paragraph 3, to protect investments, to not expropriate, so on, cannot prevent the state to change its legal and regulatory framework. Of course, there are certain limitations that are suggested here. Now, in the proposed provision, we still run into the same problems other non-Energy Charter Treaty ISDS tribunals run into. What are the criteria to apply the right to regulate? And of course, we had the seminal cases, some trying to explain. We had certain requirements. One of them is the way in which the state regulates has to be in a proportional manner with, obviously, the damage that it creates. Proportionality is that something that it's still under a great debate in practice. So the provision doesn't come with, I would say, that comprehensive framework that a tribunal would need. When it comes to the existing provisions, fair and equitable treatment, expropriation, what it is suggested is to learn from the mistakes and to amend these provisions in a way that I would say it's not unusual in the sense that they reflect what the new generation of treaty does already. And that is to exclude the legitimate, for fair and equitable treatment, legitimate expectation. The breach of legitimate expectation in itself is not a breach of the fair and equitable treatment. This was a great point of debate in the Spanish cases with arbitral tribunals going in different directions. Now it is a factor, an element that the tribunal may take into consideration in establishing a breach of fair and equitable treatment. When it comes to indirect expropriation, the proposal, because obviously the provision that we have in the Energy Charter Treaty is on expropriation, it's quite standard. There is a proposal to define indirect expropriation on what, for example, US model BITs have and deriving from that other treaties, and to have an annex which will detail in particular the specific situations where a tribunal can retain indirect expropriation. And again, here we have excluding those situations where the state has the right to regulate. So the other point, and I'll conclude here, otherwise we'll never conclude, is the valuation of damages. This is a new provision that is included. Spanish cases in particular, as you know, they adopted, well, let me rephrase it. We have a valuation for the valuation in the sense we quantification rule for expropriation, but we do not have for the other substantive protection for fair and equitable treatment, full protection and security, and so on. The proposal is to have a new article in the Energy Charter Treaty, which says that the tribunal shall apply the international standards of valuation. Again, this is not clear what that means, because this is exactly where the debate is in practice, and the tribunals, they adopt different approaches, but at least it offers a solution, at least from the perspective of contracting parties, to this problem.
I mean, definitely the balance or assessing the right to regulate will be quite interesting. You mentioned the Netherlands cases in 2021. Some refer to them as the phase-out cases, whereas the Spanish cases were the regulatory cases. And even in the context of Spanish cases, this exercise of rights to regulate is quite fascinating when you kind of take a deeper look into the cases. And as far as I'm aware, and please correct me if I missed something, but in the initial kind of surge of cases against Spain, when Spain first introduced its legislation favoring and incentivizing renewable energy, the majority of the decisions were in favor of Spain, protecting the right to regulate. But when Spain kind of went on and retracted its regulation that initially aimed to incentivize renewable energies investment, then we see this wave of cases where Spain is losing. I mean, the recent decision, and I find this particularly interesting, the recent decision, the Next Era Energy, the value of the award is $290 million. Spain is trying to annul it, but that company, Next Era, recently won an award as being one of the most progressive companies in renewable energy and kind of in its industry. So these weren't the cases of kind of fossil fuel companies versus fossil phase-out energies. These were cases of renewable energy companies kind of trying to safeguard the initial incentives for renewable energy framework. So that from my perspective, at least, that's what makes the Spanish cases interesting, and their possible implications and input on these phase-out cases that we expect to see going forward. So we'll see how and to what extent things play out. Now, before we get
just to add here, and of course you're mentioning the different cases. Also, we have to consider that this Energy Charter Treaty cases, they're not in they're isolated and by themselves. We also have the developments in other non-Energy Charter Treaty cases, and we could see the Eco Oro case recently. So I would like to have a crystal ball and add something to this. We have the phase out. We have different measures. It is a tension between the right to regulate and commitments of states. And if we look at the ISDS cases in general, where the arbitral tribunals are becoming a bit more progressive and saying, well, states have obligations to protect human rights, including the right to have a clean environment, but also companies have that obligation. So we also have, in the context of this cases against the Netherlands, Rockhopper, I understand, I think it's already a case against Italy, if not soon. We already have litigations before national courts to establish the obligation of states for a right to a clean environment. And that will have an impact on future dispute resolution in the context of the Energy Charter Treaty.
Exactly, and I think that's what makes, and I don't want to derail us further, but I think that's what will make the Netherlands the Netherlands case particularly interesting, because Netherlands, in the context of strategic climate change litigation before courts, the Hague courts have kind of been the most progressive ones in not just finding that there is a right to a healthy environment, but also ordering the Netherlands government to adopt policies in that favor, and then relying on those decisions, kind of ordering, well, at least Shell so far, to reduce their greenhouse emissions, relying on kind of a globally or internationally established obligation, recognized obligation that corporations also have a responsibility to protect the environment. Kind of that's a part of their reasonable business conduct. So it's definitely interesting to see whether and to what extent, if at all, we will see an interplay in that context. I'm mindful of the time, but we have a few questions in the chat. Some of them concern the relationship between ECT and CMIA and kind of the effect or its future in EU. So maybe we can talk about ECT's compatibility in two scenarios, briefly, to the extent that time allows us. So one is intra-EU, so the effect of ACMIA and COMSTROI, and in relation to third countries, which also recently emerged as an interesting topic. So maybe we can briefly talk about that.
I will start with the last one, and there are 2 points here. Obviously, as we know, after the Lisbon Treaty, anything that EU member states will try to conclude with third parties, third states, in terms of investment protection, has to be approved by the European Union, and this worked quite well in practice. And it's no doubt that, and just to put here, the Energy Charter Treaty is a mixed agreement, in the sense that we have a shared competence of the European Union and of the member states. I don't know, and to what extent the European Union is going to push for a disconnection clause to be inserted in the modernized treaty. My take on that is that it makes sense to do so, and to put an end, probably helped by the recent cases before the Court of Justice of the European Union, to put an end to the debate whether this will apply intra-EU. Of course, we also have the opinion of the Court of Justice in the CETA case, the 117, and we also have a request from Belgium for the interpretation of the Energy Charter Treaty in the context of ACMIA, which is still not public. I think the opinion of the Advocate General should be released soon. So these are elements in the puzzle that we know what the 117 opinion does. I think it's a preview of the future application of the Energy Charter Treaty, EU third states. When it comes to intra-EU Energy Charter Treaty application, after COMSTROI, I'm not sure if we can discuss about that anymore. It is a given. The EU member state courts will have to apply that. And I'm not going to debate, criticize. What is interesting is that when the treaty for termination of the intra-EU BITs was put forward and is obviously now in force, the preamble of the treaty has specifically excluded the Energy Charter Treaty. And it was something that was supposed to be dealt with, I would say, in a more traditional manner, rather than by way of interpretation by the Court of Justice of the European Union, in a case that had, except for the seat of arbitration being Paris and the courts of Paris requesting that opinion to the Court of Justice had not much to do with the intra-EU. But I would say this is a given, and we have to proceed on this basis. And I would say that the natural step would be for the modernized Energy Charter Treaty to confirm this by way of a disconnection clause in the treaty. What I find interesting, but now obviously is paused, is the case, the Energy Charter Treaty arbitration against the European Union in the context of Nord Stream 2. And I don't think this is the last one that we're going to see against the European Union.
On that point, I mean, there have been, and this is the last question, I promise, before we end our discussion, and I think we have time for one question from the chat, if your schedule allows it, also, Crina. There have been some mentions, so to say, that if the EU is not satisfied with how the modernization process will go, that they might consider other options, including exiting from it. So, to what extent do you think that is a possibility? Well, possibility might not be the proper word, but can we really expect something along those lines in the future, or do you think there might be other ways of dealing with the EU's dissatisfaction with the outcome of the modernization process?
Is just my guess, based on don't side me for this, but based on the involvement of the European Union in both the ISDS reform and the Energy Charter modernization process, based on the fact that the EU is the founder of the Energy Charter process, the origin of the Energy Charter Treaty, I think they will do as necessary to keep the treaty alive. We're talking here about energy security. We're talking about Central Asian states. It's more than an arbitration and maybe related to a provision or other of the Energy Charter Treaty. Of course, there is a lot of pressure. If you read the news, we have headlines like multi-billion euro lawsuits derail climate action. We have Europe's Green Deal is under threat from the Energy Charter Treaty. It's a lot of pressure coming from the public opinion, from the NGOs and so on. I think the European Union will stay in the Energy Charter Treaty.
Good, thank you. I will reserve my comments on the point. Just to confirm, I mean, the level of scrutiny and the level of criticism is really, especially the way the cases and the interplay under the ECT is phrased. I mean, I was fascinating to see that there is a special site devoted to ECT that's called ECT and its dirty secrets.
Yes, exactly.
And it's I mean, that just showcases to what extent public and civil society in general and civil organizations are engaged in that public backlash, if we can call it, against the ECT. So we'll definitely see and wait to see how and to what extent the modernization process will manage to find some balance in that context. Now, going through the questions in the chat, I think we've tackled most of them through our discussions. There is one that we didn't really get to, and I think it might be interesting to see, to just briefly touch upon it. To what extent do you think that the new technologies, so new technologies in the context of renewable energy sources and generally transfer of technologies from developed to developing states, especially in this transition process, to what extent do you think that we can see potential new ground for legal challenges under the ECT?
This is not a new discussion. My answer is absolutely. Usually these are in the context of commercial disputes, commercial arbitration. And for those familiar with this, the ICC report on climate change disputes addresses these aspects in detail. it might be in the same context we had issues related to construction, infrastructure, related to energy projects, pipelines, and so on. I don't see much difference except for the fact that this is dedicated to renewable energy. One thing is that these are really expensive technologies. So I would say that the value of the claims, if it happens to be an investment arbitration under the Energy Charter Treaty, will be a significant case. And the other, I would add to the question, the other type of disputes that might appear in the practice, what happens after, let's say, you have a solar energy development park, what happens with the soil, with the land after deciding to close that development. This is a big concern that is not addressed in practice, but I'll just leave it here. We have to think about the how much negative consequences renewable energy also has on our environment. And I think there might be litigations and at least disputes, maybe not in the context of investment, Energy Charter Treaty, but maybe before the courts related to this. I think it's still a lot to see in this context.
Absolutely, and I think what will also be not just the adverse impacts of renewable energy themselves, but also kind of how technology in that field develops, to what extent will it impact the policies and the regulatory frameworks, and just generally how the field from both the industry side, the regulatory side, and investment/commercial side, how will it interplay and continue to interplay. I'm afraid this is just the beginning, so we will just see more of this to come, and of course plenty for us to talk about, write about, and discuss about. So on that note, I'd like to thank you very much, Crina, for taking your time to talk with us today. I found it quite interesting, informative, and beneficial, and I hope we will have another opportunity to welcome you as our guest speaker in one of our upcoming events. And for our audience, please, of course, stay tuned. We have several webinars scheduled in May, all surrounding the topic of sustainable development, climate change, and investment law, investor state disputes system. So stay tuned.
I wanted to thank you as well, and also to mark the fact that we had this discussion on Earth Day today. And hopefully this proved to be a constructive one, at least from this perspective. And I would like to thank everybody for the engagement and for the very interesting questions. If you have any question, I know that there were some requests for the document of December 2020. Please send me an email and I'm happy to provide that to you.
Great, and we will also, of course, the recording of the webinar will be available on our YouTube channel, and we can also link to some of these additional materials that you might find interesting in relation to this discussion as well. And for any additional questions or anything that we can help, reach out to us, and we can liaise with Crina in getting back to you as well. Thank you, everybody. Happy Earth Day, and stay tuned for our upcoming webinars.
Bye-bye. Thank you.
Bye-bye.